Y'all ready?
Yep, I think we're good to go.
All right. So welcome to the inquiry of Busker Subcommittee. It is the duty of the committee members to avoid conflicts of interest and appearances of conflicts of interest in performing the duties as a member of this committee and the North Carolina State Bar. Any member of the committee who is aware of any personal conflicts or appearances thereof with respect to the matters before this subcommittee should disclose those now. Hearing none. Brian, you want to tell us about your final, what we hope will be the final draft for this?
Sure. So the after our meeting back in, I guess that was early April, and we talked about a number of different aspects. First of all, converting this from a formal ethics opinion to an ethics advisory, and giving a direct answer to Mr. Busker. But really primarily because of the ever-evolving nature and just the scope of the issue, we decided to just answer his questions as opposed to the broader issue. Because I think, as we noted, there were just so many different articles that have come out, even right around the time of our last meeting, that indicated there are so many more issues that we could go into, that this could be a never-ending opinion and really outside the scope of a lot of the things that the ethics committee is really concerned with. So focusing on the ethics advisory, the direct answer to these questions that can be used as a resource in the future for ethics staff, as well as, perhaps if there's any reason that we want to go down the road of an opinion later, perhaps we can do that. But nevertheless, our conversation really focused last time on, I would say, kind of three things. The first, and I'm going to go ahead and share my screen so you guys can see what I am looking at. You all see the document here?
Sure do.
All right, great. We were focusing on first inquiry and opinion number 2, and just how there was, kind of a previously referenced only, I guess, Rule 11 and the Rules of Civil Procedure and the requirement of an attorney to, I guess, really be mindful of the fact that anything that he or she signs that was produced by machine learning is really essentially adopted by the attorney. It's the attorney's responsibility. And we wanted to include a reference to Rule 3.1 as well, because that does come into play. So that I included there a very quick, brief reference just to make sure that attorneys are aware both 3.1 and Rule 11 potentially apply here. The other aspect was inquiry number 3 and opinion number 3, which really had this question about whether a firm utilizing machine learning has a duty to inform clients of their use of machine learning or artificial intelligence or what have you. The prior answer was generally no, but the opinion, or I guess I should say the paragraph really just had a very brief statement that no, it kind of depends upon the type of machine learning that we're talking about. But certainly if there's a use that requires the client's input, particularly with regards to fees or strategy and things of that nature, that may require the lawyer to inform the client of their using artificial intelligence. And that was really kind of butted against 2007 FEO 12, as we discussed. And the notion, of course, in that opinion is that lawyers who outsource work to, whether it's to non-lawyers here in the country, or in that particular opinion dealing with non-lawyers that are located outside of the country, that a lawyer does have a duty to inform the client of their outsourcing of that material. Now, of course, the opinion also states that a lawyer has a duty to supervise that, I guess, the outfit or the entity, the individual that you outsource the work to, and really it's the lawyer's responsibility to ensure the quality of that work. And we've kind of covered that in this ethics advisory in inquiry and opinion number 1, where we basically say that if lawyers are going to use machine learning, they have a duty to do so competently and confidentially, for that matter. But it's essentially, if you're going to use this tool, you've got a responsibility because it's going to be yours. And so I changed the answer in opinion number 3 to, not say yes or no, because it really isn't a yes or no question. It's really going to be dependent upon what we're talking about when we talk about machine learning. I think we talked about in our last meeting that machine learning can really cover so many things, from a program that is conducting legal research for you, such as Lexis or Westlaw, to something that is sifting through emails for e-discovery, or maybe even a program that you essentially input the critical aspects, material facts of a case, of a client's desired outcome, and the program will draft a complaint for you or draft a contract for you. So it really does kind of depend upon what we're talking about here. And that's what this opinion now says, that ultimately the attorney is going to need to respond to each case and each client individually. Of course, there's an overall duty under 1.4b to inform clients about matters, or really to explain matters to the extent that's reasonably necessary to permit the client to make informed decisions about the representation. And that is kind of I'd say the overarching rule here for those for lawyers when they are looking at using machine learning. They need to allow their clients to make informed decisions. And if you're using something, I have here kind of include this language, generally a lawyer need not inform her client that she is utilizing machine learning to complete ordinary tasks, such as conducting legal research or generic case and practice management. You can imagine how machine learning can continue to develop in terms of helping us keep up with our practices. That is a machine learning tool that's employed by a lawyer, but I don't think that's something that the ethics committee wants to say. You need to inform your client that we are using essentially a machine learning tool to manage our practice. That's not what we're talking about. What we're talking about is the second part. If a lawyer delegates substantive tasks, that's kind of I think what I focused on, particularly looking at 2007 FEO 12. When a lawyer is delegating substantive tasks relating to that representation to a machine learning tool, that is something the lawyer's use of the tool is akin to outsourcing legal work to a non-lawyer for which the client's advanced informed consent is required per 2007 FEO 12. So again, it's going to be dependent upon what we're talking about, but ultimately, this is where I went based upon our conversation in the last committee meeting. And so I'm going to pause here because I'd like to get some feedback. The last change is something that we can discuss and kind of separately, but I'd like to pause here and get some feedback of whether you think this met what we were talking about. Do you want it to, I guess, narrow, expand? Any feedback would be great.
I'm muted. I think it's great. I don't think I would change it much other than a tweak here or there. Well, one, and this is on, I don't want to get off the subject of I'll bring it up later. As to the opinion, I don't have anything that I would want to change in the substance of it. I mean, the one thing that you said down here about if it requires the client's input, particularly with regards to fees, that's the part I think that differentiates 2007 FEO 12 from my use of some office management software to do my office. I'm not charging the client for that. That's just sort of built into my fee. That's but if I'm having to go outside of that, then you really ought to think hard about whether you need to get client's consent before doing it. But given some black and white answer I don't think is easy.
Yeah.
So I like it a lot too. I'm not sure if I want to make any changes at all. I wonder, because this is an advisory, it's not an opinion. I don't think we need to fly spec it for forever, because we could even put in something that it's likely going to be something you should do X with, but I feel like that's going to clutter it.
Mm-hmm.
And again, this is I'm just going to say it again, an advisory, not an opinion. So
Yeah.
Looks good. Thank you, Brian, by the way.
I like it.
Yeah, I think that was just the line that I wanted to get that feedback on, of a lawyer delegating substantive tasks.
Yeah.
What that means can probably mean a variety of things, but
Right.
I, for whatever reason, just kind of seeing the breadth of different programs that are being made available, that are in development. I think that is where a client, maybe just putting myself in the client's position, what I want to know that that my lawyer is really relying upon a program to generate the contract, as opposed to the lawyer that's producing it, even the lawyer that has previously drafted a contract and they're reusing a lot of the same parts because it's a it's a generic lease or something like that. Do you have that desire to know that? And I guess that's where it seems to be more akin to outsourcing to someone else. Someone else is actually producing it, and the lawyer is essentially checking the work, is reviewing the work for substantive accuracy, being a little different than creating it themselves. So if we're all good with that, then we can move on. Okay. Hearing no other comments.
I'm good with that.
Oh, good. Great. Thanks, Tom. And Kevin, I saw you nod. I think you're all right. Great. Thank you. All right. So then the last thing was we had talked about combining inquiry / opinions 4 and 7 because they dealt with legal matters, or at least they touched upon legal questions, namely the attorney-client privilege. Inquiry number 4 kind of talks about, or kind of has this parenthetical right here. This question assumes the documents being reviewed by a machine learning tool are protected by attorney-client privilege, whereas inquiry number 7 just outright asks, is this information aggregating quantifiable data? Would that be protected by the attorney-client privilege? Now, the ethics committee, of course, historically does not opine on matters or legal questions, particularly with attorney-client privilege being an evidentiary thing. It is a legal question. We'll talk about confidentiality till we're blue in the face, but attorney-client privilege, we will pass on. So when I tried to start combining these things, I was running into problems because inquiry number 4, starts off with its own little set of facts, but then inquiry number 5 refers back to inquiry number 4. And then when you get into inquiry number 7, followed by 8 relies on 7, and they do have slightly different fact patterns, particularly with regards to 7 and 8 dealing with aggregating data from a variety of sources. So again, that's where, as I said in my email, I was starting to combine them and realized I was creating a bit of a mess. So I just I left 7 alone. Other than to note, again, this is a legal question. Really, the biggest change was in 4, kind of clarifying at the outset of this opinion, this parenthetical about whether or not the documents are reviewed by a machine learning tool are protected by attorney-client privilege is something that we are not opining on. That presumption that the person submitting the inquiry included is simply not something that we are going to address, and we want to make clear that we are, I guess, not saying yes we agree or no we disagree. We're just staying completely silent on that count, and then moving on from there. So that was the only other change that I made to this. I didn't know if after reading it, if it felt clunky or if you felt like it should be combined, and there might be a better way. So your opinions are welcome here.
Now, to Amy's point earlier, this is an opinion, and I don't want you to twist yourself in knots trying to do those things. I mean, the way they're set out it's very clear. I'm not concerned at all about that. I will just not a couple of very non-substantive things.
Yes.
In inquiry number 1, in the third line, it says malpractice liability relative to if and lawyer, and it should be lawyer. And then right there. And then, and this is a point of personal preference and at risk at sounding pedantic. If you could do and if everybody disagrees with me, that's fine. If you could do a search and destroy and replace of utilize with use, or utilization with uses, or with use, or utilizing with using, that kind of thing. That's just me. I don't care if it goes out the way it is, but it is something I think that we could that makes it more reader friendly.
Right. I'm fine with that. Everybody else is all right with that. Yep.
All right. Is that, I mean, if it doesn't bug anybody else, I don't know, but it just.
Utilization takes more letters, so it sounds fancier.
Yeah.
Right.
I just like to use.
I was getting ready to ask you why it bugs you, but I don't need to add to my list of things in life that bug me. So.
Oh, I know.
I'm good.
I've gotten over now my personal dislike of using impact as a verb, because actually I find myself doing that now when I'm not really thinking about it. It just comes so prevalent. So
I can very easily make that change. No problem. I'm going to just write that as a note afterwards to make sure everything flows instead of trying to edit while we're meeting.
No, that's fine.
Anybody else have anything? I know, Kevin, you had sent that change to inquiry number 1. There was an extra on there. So you can see here on the screen, I've eliminated that. Just instead of on upon, it's just upon.
Gotcha. Well, cool. Everybody feel good about it? If so, let's all give thumbs up and approve to send it to the full committee for does an advisory opinion. It does go to the full council after the committee.
No, it doesn't. So the this is something that the ethics committee can issue. An ethics decision has to go to the full council for approval. This is typically, these ethics advisories are issued sometimes by staff, sometimes by the chair. When possible, though, I do like to get them before the committee because they ultimately have to be approved by the committee. So if time is not of the essence, then I like to put them before the committee. In this situation, because it went to the subcommittee first, then I think it needs to come out of subcommittee to the full committee. But I think if the ethics committee approves this at the July meeting, it will simply go out to Mr. Busker, resolving the inquiry. And if there's, additional talk after that of, well, maybe we do need to have this just general statement about a lawyer. I think really when we look at inquiry number 1 and opinion number 1, that one saying that, if a lawyer is going to use something like this, it's on the lawyer to do so competently and confidentially and with proper supervision. That is I think the foundation for this. And perhaps that could be looked at similar to, we had I don't know if you all remember, I think about a year ago, maybe 2 years ago, we had an ethics advisory on a lawyer representing himself, representing his firm, of which he was the sole owner. And that was an ethics advisory that the committee felt, I like this, let's make this an opinion. That it could have that same thing, but I think for the reasons that we've talked about, the only thing that I would really be interested in making an opinion would be the first inquiry, because it touches on those foundational issues and not getting into all of the other things that come with machine learning and artificial intelligence. It's just it's so varied right now. And I feel like anything that we issue, potentially even issuing that as an opinion, could be stale. and outdated fairly soon. What happens? So I think it's a good route.
Good. All
All
right.
right. Well, I think that wraps us up.
Fantastic.
Anything else that you all want me to do?
Well, thank you all for all hard work, especially you, Brian. I just can't tell you how appreciative I am of you continuing to put me on all these committees having to do tinfoil hats and beta rays and all that fun stuff.
You're my litmus test.
Yeah, there you go.
And Warren can figure this out.
Yeah, exactly. If that stupid third grade monkey can figure it out, anybody can figure it out.
If the shoe fits.
Yeah.
I don't know.
Well,
Third graders might know a lot more about technology than we do these days, so we should be
Yeah,
careful.
that's true.
Oh,
No kidding. I made
don't
some
get me started.
assumptions there.
I'm the first grader that's over there in my house, just turning on the camera, turning on mute, like just clicking around.
Yeah.
Like, where are you going on your Google Drive? How do you know you have a Google Drive? Anyway, I appreciate you guys. I'll get this thing ready to go. It'll be included in the ethics agenda, and this will be before the committee in July. And I look forward to seeing all of you in person in Ashland.